Is a surviving grandchild an owner of the cemetery plot left behind by the deceased grandparent? To find out, you have to read Liere versus Allen E. Fricke Memorials, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is part of a special series I'm doing on cases relevant to the elder law and estate planning community. This is the episode on the case of Liere versus Allen E. Fricke Memorials, Inc. It's published by the appellate term of the Second Department on August 17th of 2023. The citation for this case is 2023 New York Slip Opinion 50865U. The issue in this case is whether a grandchild, a surviving grandchild of a deceased grandparent, is an owner under the law of a cemetery plot, such that they can make changes to the plot and not get sued for it. So the law you have to understand to appreciate what's going on in this case is there's 2 different issues. The first is that when a person devises or bequeaths their property before they die, that's called making a will. But if they don't do that, they're said to be intestate, and their property passes pursuant to the rules of intestacy. But you should know that there's a strong presumption against partial intestacy. So if a person makes a will and makes a residuary clause that all the stuff that's not specifically mentioned should get passed to Jenny, and they fail to acknowledge one or more contingencies, the court is allowed, using this presumption against intestacy, to take that to avoid the ambiguity and sort of go to the intent of what the person meant to do. And they can then say, well, they meant not for this to happen, where there'd be a partial intestacy, and we will just go forward with the intent that we believe the testator, the person who drafted the will, had. But you should know, and this is the important part for this case, is that under not-for-profit corporation law, NPCL 1512, it talks about the right, this is cemetery corporations. This is law for cemetery corporations. Under NPCL 1512, with respect to lot owners, so it says that with respect to the death of an owner of a cemetery plot, it passes to the people that it can pass by will, but only if specifically named. It will not pass by residuary clause. You can't say, and the rest of my estate goes to Jenny. You have to specifically name the cemetery plot as an item to be passed in the will, or else the statute says if you don't specifically refer to that plot, then it gets passed by articulated law of intestacy. It goes first to his or her descendants, then surviving, if none to the surviving spouse, and so on. Okay, so what happened in this particular case? The facts in this particular case are Herman Henry Liere, he went by the name Hank, but Herman Henry Liere bought a cemetery plot and monument in 1978. The plot was deeded to the Herman H. Liere family. He had a spouse at that time and 4 children. His spouse then died, and in 1997, one of Herman's sons died. That son had a child, who's the grandchild. He becomes the defendant in this case. In 2008, Herman died, leaving behind a will, but not specifically naming this cemetery plot in the will to be passed on. It was silent as to the cemetery plot. In 2016, another one of Herman's children died, named Lorraine. She had no spouse or children, and her will was silent as to the cemetery plot as well. So then let's talk about the instant issue. The instant issue is that the grandson, that grandchild that we mentioned before, he hired a memorial company to come to the monument and change the plot, basically the headstone, and add a senior to it. I guess, it doesn't say that, but I assume that Hank had a son who was junior, and that was probably the grandson's father. Once he hires the company to come and add the letter SR, the letters SR senior to the plot, the other children get mad and file this lawsuit, and they sue, claiming negligence, trespass, and conversion. And they say, and this is the sole basis for their lawsuit, they say that they have exclusive ownership of the plot, and the grandson is not an owner, and because he's not an owner, he had no right to modify the plot and the monument. So that's their lawsuit, that the grandson is not an owner. So it goes to the appellate term, and that's what we have here, and they go through NPCL 1512, like we talked about, and they say that here, it's either passed one of 2 ways, by specific bequest in a will, which we don't have here, or through that specific rule of intestacy, where it goes to the owner's descendant, then surviving. So the question is, who's a descendant? And that's what the appellate term answers here. And they go through Black's Law Dictionary and they say a descendant is someone who follows in the bloodline of an ancestor, either lineally or collaterally. And examples are children and grandchildren. That's specifically what Black's Law Dictionary says. Examples are children and grandchildren. What we have here is a grandchild. They also then look to the EPTL, the Estates, Powers and Trusts Law, which basically describes, it doesn't describe the word descendant, but it describes the word issue and includes grandchildren as an issue. So they say under this law, under N PCL 1512, the grandson of the decedent here, the grandson of Hank, is an owner. And he's an owner two ways. First, he is a descendant then surviving when his grandfather died, because his portion passed to the deceased son, and that portion then passed to the grandson. But he's also an owner a second way, because Lorraine, the other child who died, she had no spouse and no children. And so when she died, her portion of that cemetery plot also passed partially to the grandson. So the grandson is an owner. And by that term, but the fact that he is an owner, and that was the only issue before consideration in the appellate term, they dismissed the case because he, in fact, is an owner partially of the cemetery plot. And therefore, they don't decide anything beyond that, whether he should or shouldn't have done what he did. But because the whole basis of the lawsuit was, is he an owner? And he is, case dismissed. That's the case of Liere. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.